any moment, Donald Trump could receive word on two rulings with profound implications for his financial, business, legal, and political future. Judge Artur Engoron was efforting to release his decision in Trump's New York civil fraud trial by today, which could result in a $370 million fine for Trump and a ban on doing business in New York. It has also been just over 3 weeks since a D.C. Circuit Court of Appeals heard arguments over Trump's claim of having absolute immunity from criminal prosecution in his federal election interference case. It's been more than 50 days since the proceedings in that case have been put on hold. And with each passing day, it gives Trump the delay he wants to try and keep the case from reaching trial before November's election. Remember, prospective jurors were supposed to appear next week to fill out a written questionnaire for use in the jury selection process for the March 4th trial date. That, of course, is now on hold. Joining me now is Melissa Murray, professor of law at New York University and MSNBC legal analyst. And Melissa, all of these cases are important, but I kind of feel like the American people should know if they're going to elect the guy who says he can use SEAL Team 6 to kill his political opponents. I feel like that's kind of like a baseline question that we kind of need answered. Why do you think? You go ahead.
Well, it was certainly the most provocative question at that oral argument, and one that really elicited an eyebrow-raising answer when Donald Trump's lawyer said it was a qualified yes, he could do that, which was essentially an admission that this president, at least in his view, is above the law for really egregious acts. And so I'm surprised that it's been almost more than 20 days since the D.C. Circuit heard oral argument in that case, and we still haven't gotten a ruling. Every day that goes by is a day that we get further and further away from that stated March 4th trial start date that Judge Chutkan put in place. She has already indicated that she is likely to push that date out further. But every day that goes by and the farther we get from that date is basically a win for Donald Trump, who is not necessarily just on the art of the deal, but is really practicing the art of delay.
Let me read you what Politico wrote. Even if the appeal were resolved next week against Trump, that calculation would put his earliest trial date in late April. But if the D.C. Circuit and the Supreme Court take additional weeks or months to deliver a final ruling, the opening days of Trump's trial could be pushed to the summer or fall. Or if the Supreme Court agrees to hear Trump's bid for immunity but won't take up his appeal on an emergency basis, the trial could remain on hold until after the election. And if Trump wins, he would be virtually certain to shut down the case. Let me just put up the legal calendar and the political calendar kind of together. We're talking about these trials that are supposed to be happening in July. That's when the Republican National Convention is. November 5th is Election Day. We literally could go into knowing that Trump is the nominee, but not knowing whether he has the immunity, complete immunity to kill whoever he wants using the military, and go into Election Day not knowing the same thing. Is this something that these appeals court judges, in your view, take into account?
I think everyone has to be taking into account what this calendar looks like and the really, really important substantive issues that are on the table here. The best that I can guess from what is going on and just sort of the work that I have done in appellate courts is that there is likely 2 judges, probably 3, who agree that there is no such thing as qualified or as absolute immunity in this case. And they're really sort of wrestling with how far to go. It could be the case, the judge that seemed most skeptical of the idea that Donald Trump was not immune from prosecution was Judge Henderson, who's the senior member of that panel. And if she is in the majority, which is she agrees with the judgment of her colleagues and they're all there together and there's a majority for it, she gets to assign the opinion. And so it may be that she's taking her time writing this and they're trying to sort of work out the details. Or it could be that she's not in the majority and she is writing a dissent. And if that dissent is something that she spends a fair amount of time on and they go back and forth between the majority and the dissent, that's going to take a lot of time. But again, any time taken, any delay here is a win for Donald Trump.
You know, there is a sense I think a lot of people have that the judge in the documents case, because we also probably should know if the person that, people are considering electing president was stealing classified documents and disclosing them to people who didn't have authorized. That's probably something people might want to maybe know. It feels like she is slow walking that case. We know Jack Smith is, met in a skiff about questions of whether Donald Trump's attorneys can get to look at some classified documents in that skiff and see them, which seems bananas to me that they would ever let him see them again. But is there a sense of the lack of urgency generally in the appellate divisions and in the appellate world? It is alarming to me, and I wonder if it is alarming to you.
Well, I think it is alarming. I mean, there's a lot that might go to explaining it. I think that of the cases, the one concerning the classified documents is the one where the prosecution probably has the lightest lift to establish guilt, because basically he had the documents, he did not turn them over. There it is. But it's also the most complicated in terms of evidence, because so much of the evidence in this case is going to be classified, and there's all kinds of procedures and protocols for dealing with it, as you just suggested. And the defendant has certain rights here. He has to be able to see the evidence against him. Should that evidence be shown to him in a SCIF where it's protected, or can it be out in the open? What sorts of protocols will we take to ensure that it's not further disseminated and is insecure as it was at Mar-a-Lago? All of those are real questions, and they're before a judge who is a Trump appointee. And that's not really the issue. The fact is that she's not a very experienced judge. She's only been on the bench for a limited amount of time, and she hasn't had a lot of criminal trials, and certainly not a trial like this where there are really complicated evidentiary issues.
Yeah, what a world. Melissa Murray, always appreciate you. Thank you. And